got some things figured out. Although, hold on, there might be a question. Give me 1 second here.
You were showing up over there. Oh, just super late.
Oh. Well, good to know. I popped off the screen, and I apologize about that, but there's apparently a delay with what I'm actually saying by about 5 seconds to what's being cast on there. So, guys, thank you so much, ladies and gentlemen. We are here for a very in-depth dive into some policy language that we continually see over and over again that carriers are getting wrong. I really think this is going to be an insightful lunch and learn today. For those who don't know, my name is Tony DiUlio. I'm a partner at Wheeler, DiUlio & Barnaby. My firm is practicing solely involving property damage claims. So we handle claims against insurance companies when they deny claims, underpay losses, claims against neighbors, a wrongful contractor. Really what we tell people is if something goes wrong with your property, we can probably help. Behind the scenes, I have one of my associates, Vincent Dodo, who will be answering any questions. If you guys have questions, throw them in there. One of the really great things about this is you've got an opportunity to ask live questions about the things that we're going over so that we can address them. We've gotten pretty good so far at adding the questions to the screen while this is happening so we can get that taken care of. We also had a ton of questions come in beforehand that I'll be addressing, as I always do, at the end of this talk. There's a good chunk that I'm going to try and get through. I'm going to still try and keep it under the hour, but there's a lot of stuff as I was prepping for this one that I realized that people are missing. So I really want to make sure that I cover as much as I can during this lunch and learn. But if you have any additional questions after this, you can reach out to me. Right here is my cell phone number. This cell phone is on morning, day, and night, and I am available pretty much at your beck and call. I don't give it to clients all the time because, as you know, clients can sometimes be tough with these cell phone calls, but for adjusters, contractors, whoever you may be, absolutely feel free to reach out. I'm also somewhat busy, so if for any reason I don't get back to you, bug me again. Shoot me a text, give me a call, say, hey Tony, haven't heard back from you. I have no problem. You have fair game to reach out to me as much and as often as you need to. I'm okay with it. So with that being said, most people should be signed on. I know people are going to be joining. We've got a good number of people on this one, so let's get diving into this. Before I go into the language, I do want to let you know about MAPIA. MAPIA is the Mid-Atlantic Association of Public Insurance Adjusters. It is a group that focuses in New Jersey, Pennsylvania, and Maryland and does a ton of great work for this industry as a whole. MAPIA, I am the litigation counsel for MAPIA. We provide live CLEs, all included with your membership. We just had our first post-COVID live meeting. It was a huge success. We provide lunch for people, a happy hour afterwards. We're going to be planning the holiday party where there's going to be more food and drink. You get the CLEs. You also get live interaction with myself and other attorneys in the industry to ask questions of and have conversations about what's happening in the field. The other great thing, and probably one of the most important things, is MAPIA has its own lobbyist to help combat what these insurance companies are doing in the back end when it comes to the laws. We have been incredibly successful with our lobbyist. I really cannot talk highly enough about him, but we can only keep fighting up against these giant monolith companies with things like lobbyists if there are members. It is only $300. This is not a ton of money, and it's tax deductible. I can't think of a reason not to join. You get a ton of added benefits, not to mention supporting our industry as a whole. It also lets you interact with other adjusters in a non-combative format, right? It's not seeing them on the street, it's seeing them in an area where we can talk openly together and help everybody as a whole. So I really recommend doing it. It's mapia.org, MAPIA.org to join. Highly recommend going. So, enough shameless plugging. Let's talk about specific policy language that we see at my firm over and over and over again that either adjusters are arguing wrong or just completely missing the point on. And the first one that we've got today is our good friends at Allstate. Allstate is unique in this language. Their all-risk HO3 language is right here. Now this is the language that provides coverage for an insured under this policy. This is it. This is the whole kit and caboodle, because what this, like most policy, says is you're covered for it unless you're not. But Allstate's unique because of this language. And right here, Allstate says sudden and accidental. That phrase in our industry comes up on what appears to be a daily basis. But the reality is, Allstate is relatively unique in the fact that it requires both sudden and accidental. Most carriers don't have that language. It will either just say accidental direct physical loss or just direct physical loss. Some carriers, and specifically with commercial policies, go even broader and say risks of direct physical loss. Now, there's some litigation on that issue and what that really means, but the reality is we don't have a burden under any policy except Allstate to prove the sudden nature of a loss. That's big. That's really big, because you don't have to show, oh, this was a one-time event. You don't have to show, oh, this only happened over a short period of time. Those aren't requirements under most policies. And even under Allstate's policy, the term sudden isn't defined, so we have to look further into figuring out what that really means, what sudden really means. And that can really be determined based off case law that is specific to a person's state. But the whole point of this is you shouldn't be putting the burden of sudden on yourself with other carriers when it doesn't exist. So know the language of the all-risk policies that you've got and that you're adjusting, and recognize that you don't have certain burdens that the carrier might try to claim you do have. The other important language, and I want to say this here, and I'll be saying it again a little bit on some other slides. When you have an all-risk policy like this, you have zero responsibility to say what caused the damage. Zero. You don't have to say it was wind damage to the property. You don't have to say it was a broken plumbing line. You don't have to say it was a collapse. All you have to do is say there's sudden and accidental direct physical loss to a property. That can be the cause of loss that you put in your letters. You can just write sudden and accidental direct physical loss. That's enough to trigger coverage. It is up to the carrier then to show an exclusion. I want to make sure that we are getting comments. If anyone can throw a comment in there, because Vinny's kind of tag teaming in since my partner Mario is away. Throw some comments in there. You can literally just say the word hey. And if we're not getting it, we'll take a 2-minute break to find where those comments go. Since I'm on this side of the camera, Mario does that side, so I want to make sure that we can see those. All right, so that's the issue with this. You don't need to designate the cause of loss. I'm going to say that again later because it's going to become important in some other slides. Our second offender, and our most common offender of the day you're going to see, is State Farm. Now, this specific language with State Farm is not necessarily unique to them, but I'm using them as an example because I preferably don't like State Farm and want to put their name up there as often as I can to remind people how terrible I believe they are as an insurance company. But this language is common in a lot of policies, and this is the anti-concurrent causation language. I did a longer talk on this, so I don't want to spend a lot of time on it, but it's important to reiterate because I actually saw a lot of questions recently in some of the Facebook groups I'm involved in about this language. Anti-concurrent causation language is confusing, and it gets even more confusing because of what's known as the ensuing loss coverage. As you can see here, the language on this side takes away coverage by saying, if anything else happens as a result of an excluded loss, you're not covered. And it specifically says, or occurs as a result of any combination of these. As a result, it occurs afterwards. And then, later on in the policy, they come back and says, however, we will pay for any resulting loss from these items if the resulting loss itself is not covered. That you cannot have both of these two things existing at the same time and actually working. So luckily for us, this is ambiguous and it leads towards coverage. It's important to know this because if you are getting denied claims based off of anti-concurrent causation, you very likely have an out as the result of the ensuing loss provision. So if they are citing this language in your denial letters, know that there is probably this language to help save you and get you back into coverage. They do this a second time in State Farm's policy and in a lot of others. This is the language that starts the section regarding things like contractor negligence or even homeowner's negligence. If there is faulty workmanship, you have the same issue. It says in this provision that or after the loss, you're not covered if after this loss something else happens. But then they give it back to you the exact same way, as long as the resulting damage is covered. So if you have a contractor who has improperly done something at the property, you're not covered for what they improperly did. Let's say a roof, right? If they put down a flat roof improperly, you can't get paid for the flat roof. But if as a result of that flat roof being done improperly, water gets into your property, you're covered for that water damage. Even though it's all the result of the contractor negligence, you've got the ensuing loss coverage. So it's really important to recognize if they're trying to tell you this exclusion applies, take a look and see if there's that ensuing loss coverage under the policy. That will be extremely helpful. All right, let's go to our third offender of the day. We've seen some Allstate, we've seen some State Farm. Now we've got Travelers. Travelers has this provision within their policy, as do a number of other carriers. I'm picking on certain carriers simply because I like to. Travelers is unique, though, because of what happened with this. Travelers had a provision in their policy that says you are not covered for rot, mold, that kind of stuff. And then they give it back to you and say, if you have a loss that causes rot or mold, then you've got coverage for this. And a lot of times, like in travelers' policies, there's a limit on this. So I think in this policy it was $5,000. Well, what had happened in a class action that we filed in one, it's actually across the country. It was all the states that Travelers issues policies in. We were successful in this. Travelers was denying claims for rot because they were the result of long-term leakage. And I asked the obvious question that most people in this are probably thinking, well, isn't all rot that's ever existed the result of a long-term leak? The answer is yes, of course it is. But what Travelers was doing is saying, well, this coverage that gives it back can't apply ever because it's always the result of a long-term leak. It was phantom coverage. That was a fun term that we came up with because they were saying you had coverage for this, but you were never going to get it. Travelers recognized that this was clearly improper and settled the class action as a result. Not only did we get the breach of contract damages on that, we got bad faith damages and extra contractuals because State Farm recognized how wrong they were in doing this. So the other big thing that came from this, and what I want the biggest takeaway to be for you guys, is Travelers made a practice change. As part of the resolution of this claim, Travelers said that they would no longer be denying claims for rot based off of the long-term leakage provision if they had this additional coverage. So what does that mean for you? If you have a claim with an insurance company, especially Travelers, where they have denied your loss, even though you denied your rot or mold claim, even though this language exists and they're claiming the long-term leakage provision, you've got to let me know. It's a breach of the agreement that we have with them, and it could put them in some serious deep water. So make sure you do that. Now again, this doesn't just apply to Travelers. If you have another carrier who offers additional coverage for something like rot, and they've denied the claim because it was the result of a long-term leak or some other exclusion, and you recognize, well, that would mean this additional coverage never applies, that's something that we can fight back against. And that's the type of thing that class actions are made of. So let me know if those things come up, because we've got that experience to help fight these things and actually make changes that affect you guys in the field, not just the back end of this. So we're going to jump back to Allstate. You're going to recognize that the carriers that I keep naming this are going to be the big players. I don't want to focus on the small local carriers, because the reality is not everybody on this call is local, and I want to make sure it can help as many as possible. But remember, this language isn't always unique to one carrier, so you can likely apply this to multiple carriers. This one, however, is relatively unique to Allstate as far as I can tell. We have language in Allstate's policy regarding how they will pay for a loss, and they've got their settlement options when they are paying for that. And most people don't look at this when it comes to the adjusters that I speak with. And this is, of all the slides, probably the number one missed item with Allstate claims and how they are being adjusted. With Allstate, they have only two options on how they are paying for a claim. Number one, they can, this is we, have the option to repair, rebuild, or replace any or all the damaged building, yada yada, with like, kind, and quality. We in this sentence means Allstate. So Allstate has an option to repair, rebuild, or replace. It's their choice. They can do that themselves. If Allstate is not going to do it themselves, they only have one other choice. They will pay, Allstate will pay for all or any part of the damaged, destroyed, or stolen property as described in Condition 5, how we pay for a loss. Now what does this mean? The option to repair does not exist in the payment world. This is not a payment. They are not paying to repair, rebuild, or replacing. They are actually doing it themselves. When it comes to payment, all they can do is pay for the damaged item. I hope you recognize how big that is. That means they cannot be paying for repairs. They must be paying for replacements. They must be paying for the damaged item itself. Let me give you a great example. You've got a plumbing leak that damages a wood floor. That wood floor probably could be sanded and refinished. Allstate has the option to do that. If they want to send someone out and accept the liability for whether or not that job is done correctly and sand and refinish the floor, they have that power. However, assuming, which they pretty much always do, don't want to send someone out, the only option they have is to pay for the wood floor itself. That means replacement of that wood floor. Sanding and refinishing, which is a repair, is no longer on the table. This would go for cabinetry, wood floors, any number of items. They cannot pay for repair, they must pay for that replaced item. Now adjusters always tell me the same thing. Well, hold on a second, this is kind of crazy, right? They wouldn't really be on the hook for replacement of items in, let's say, a smoke loss, right? No, they are. If you've got a smoke loss on a property and items get damaged as a result of that smoke, they don't have the option to repair those items, i.e. clean them. They only have to pay for the items itself. That makes such a huge difference, and this is a giant loophole in the Allstate policy, but we need to start using their language against them. They do it to us, and adjusters seem to be tentative to want to do this for some reason, but the reality is you can use this against them the same way they use policy language against us. They wrote this, not us, so let's use it to our advantage. Until they change it, let them change the policy, that's okay too. That's a really big one. If you've got questions on it, please let me know. Are we able to see the questions as they're coming up, comments from people? Are we good? If you guys have written comments, which generally if I ask for a comment, you guys will, we're going to take a break in a few minutes because I want to make sure we can find them because I don't think we're in the right spot. But we're going to keep going before we can just to see what else we can get through here. Hey, back to Snake Farm. Oh, sorry. Let's fix that. Sorry about that one. Back to State Farm. Here's a really great one. This is a personal fight of mine and one that we've continued to fight and continue to be successful on. This is State Farm's language regarding leakage over a period of time. They don't pay for continuous or repeated seepage, yada, 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 which occurs over a period of time. Now, anyone that has heard me talk about State Farm before has probably heard this before, but I want to make sure everything about this problems within the policy are contained in one spot. So I'm saying it again. This is ambiguous. On its face, it's ambiguous. State Farm's own representative, Ed Toussaint, for anyone that works with him, has said that this is ambiguous, i.e. State Farm's admitted that this is ambiguous. And the reason is clear. How long is a period of time? Is it a minute? Yes. A second? Yes. A year? Yes. A millennia? Yes. They are all periods of time. So, which ones are excluded? Is it the leak that when you're gone for a long weekend, you're out of your house for 3 days? Is that excluded? It's continuous over a period of time. How about the leak while you're away at your son's baseball game? And you're gone for 3 hours, and a pipe breaks under your sink and it's just flowing freely. Well, it was continuous over 3 hours. That's a period of time. Is that excluded? Of course, you have no way to know what State Farm is going to do with this, and that makes it ambiguous. If you have these claims, we've continued to be successful on them, let me know. I am happy to fight State Farm on every single loss where they're claiming a period of time as their exclusionary language. If you have it, let me know. I will fight those claims. In that same vein, we've got an example from Allstate. Now, again, I'm using Allstate because they're one of the big carriers, but this language is consistent with other carriers as well. And there's two really important things I want you to take away from this provision. First, this provision relates only to plumbing leaks. Now, this is big because a lot of people in this industry hear the concept of 14 days or more, or weeks, months, or years. That's the other one that's used a lot, like in Allstate. But this provision only relates to the leaks from plumbing, not from, let's say, a roof leak. Allstate cannot apply this language to a roof leak that has occurred over 14 days or more. Does not apply to this. And it seems like something that would be obvious when you take a look at it, but everybody has this assumption that if it's a roof leak that's been occurring for, 14, 15, 16 days or 5 months, that this language would apply. The reality is, under Allstate's policy and a number of other carriers, if you've got some external source of water, not your own plumbing system, an external source of water like rain that has been coming into the property and the homeowner didn't know about it, you're going to have coverage regardless of how long that leak had been going on for. That's huge. That's really big information because I hear adjusters constantly tell me, they turned that file down because clearly the leak from the roof had been going on for a long time, and thus it wouldn't be covered. But check the language. If the Allstate policy has this, again, I can tell you other policies do as well, you want to make sure that you're applying that language appropriately. There's another big aspect to this, and this applies to Allstate and all other carriers. Just we have the proof against Allstate. This policy language only excludes the damage that happens on day 14 and forward. In other words, the first 13 days are covered. So your job as the adjuster, all you need to do whenever you get this denial from Allstate or anyone else is to say, I understand any damage from 14 days or more is excluded. The damage I'm claiming is just from the first 13 days. This is the areas that the water would have touched and would have damaged in the first 13 days. It doesn't matter if it got more wet on day 14 or 15 or 16. If this wall was damaged on day 1 through 13, it's covered. It can get mold later, still covered. It can get rotted, it can fall down. It is covered in the first 13 days. Now, not only is that clear based off of the language of the policy, Allstate has admitted it. So, I, as many of you know, am a pretty avid trial attorney. I love trial work. I like beating up on insurance companies. And this was testimony from Allstate during one of those trials. And anyone that works in this area probably knows Lou Mincarelli. This was from Lou himself. And I asked the question, if that drain line causes water to escape into the property, that first time the water escapes, that is covered by this policy, correct? Yes. And in fact, it is actually covered up to 13 days of leaking in this policy because it doesn't get excluded until it's been going on for the weeks, months, or years, correct? Yes. Now, I didn't want to cite everything. After this, the judge actually asked, can you say that again? Can you clarify? Because they weren't sure, and I had the testimony, so I asked it a different way. And I said, when a pipe breaks, it can leak the first 13, it can leak, and that was an error, the first 13 days it's leaking is covered under this insurance policy, correct? It does say weeks, yes. Correct. And it's the stuff after the 14 days and on, that portion of the loss is not covered, correct? Right. The long-term damage is not. That's monumental in our industry because that means as long as you can tie damage into occurring in the first 13 days on any of these denials, you're going to be able to get coverage. And it's going to be up to the insurance company to prove that that damage occurred on day 14 or on. And they're not going to be able to do that, right? Because you're not making a claim for anything that occurs after day 14. And as long as you do that, you've got coverage for this. I want to take a very quick break because I want to go behind the screen. Give me 2 minutes to figure out where these comments are going. I will be right back. Thank you, guys. found out a resolution. I also found out that apparently the screen's pretty dark, so if I stand closer to the screen, it works out a little bit better. I thank you for your patience. We now have the comments, and I do see a number of people on there. So let me get to the next one. All right, this is a big one. Appraisal. Now, I want to make sure I note something for you guys. I did an entire talk on appraisal either last month or maybe the month before, and I would highly recommend going and reading that section, or reviewing that video, I should say. We go much more in depth about the appraisal language, but I want to make sure that we touch on it just a little bit here. And what we have here under this original old language from appraisal is it says if you and we fail to agree on the amount of loss, either may demand an appraisal of the loss. Now, this language has been hotly contested. It is contested and it's different in every state, and that's one of our problems. But generally your argument is always going to be the same, and you should always send the exact same letter to the insurance company when you make the demand for appraisal. You want to list, this is a letter for a demand of appraisal, and you can cite this policy language, and you can state after that, as of now, we are valuing this loss at X. You are valuing, you being the insurance company, this loss at Y. We do not agree on the amount of loss, and as such are invoking our right to appraisal. That's it. That's all it needs to be, because the language is relatively simple here, right? If you and we have failed to agree on the amount of loss, either may demand an appraisal of the loss. That's it. Now, I want to stress, different states have different opinions as to what the amount of loss means. I don't know how, because anyone in this industry clearly knows if I'm saying X value for a loss, you're saying Y value, that's a difference. Doesn't matter why it's different, just that it is a difference. And as a result, you've got a demand for appraisal, but some courts have come back and said, well, things like scope cannot be appraised. It's a nice pop-up of that language, but this isn't always true anymore. Carriers are starting to change the policy. Let's take a look, just by way of example, at what Farmers has in their language. That's the new provision from Farmers. I'm clearly not going to go through that, but what you need to recognize is there's a lot more language under the Farmers policy. If you ever want to go through that with an attorney, let me know. I'm happy to do it, to go through and to see what exactly we need to do to comply, but make sure you're reviewing that policy language. This language has not really been tested with the courts either, because it says some ludicrous stuff, in my opinion, like you have to go to appraisal before going to litigation, and stuff like that is generally not going to be enforceable, in my opinion, but it hasn't really been tested. So if you do have questions about it, let me know. Oh, another one from our good friends at State Farm, and this one involves a little bit of setup. Anyone that has had State Farm since 2016, when this provision came out, had a policy notice change that came. The notice says this, and if you've been in some of my classes, maybe we've gone through this. I apologize if I'm repeating it, but again, I wanted everything in one spot to send people to if they had questions. But this language under the FE 2340 started with this provision. And it says potential reduction in coverage. Although not intended to change coverage, this change could potentially reduce or eliminate coverage depending on how it is interpreted. And in that regard should be viewed as either an actual or potential reduction in or elimination of coverage. What? I'm not entirely clear on what that means. I know what State Farm wants to say it means, but here's the problem. The first line here says State Farm is not intending to change coverage, meaning everything is being kept status quo. So if you were to look at an old policy before this language is in there, it means the same thing as this one. But State Farm is telling us that depending on who is interpreting this, not telling us who, maybe it could potentially reduce or eliminate coverage. How can you have it as both no intent to change the coverage, but actively acknowledging that this might reduce your coverage or completely eliminate it? This is misleading. And the court agreed. We had a trial on this issue, and the court awarded bad faith damages because of the misleading nature of this. They awarded attorney's fees against State Farm because this provision was unbelievably misleading. And it gets even worse, because when we look at the coverage that this changed, they called it additional coverage. So now, we have gone from, although not intending to change it at all, right? We're not trying to change anything. But we might be eliminating or reducing this, so you should probably take it as an elimination or reduction. But we're calling it additional coverage. If that's not misleading, I don't know what is. Now this provision, beyond that fact, is not really clear and certainly something that needs to be contested over time. Now we've contested it again and been successful, so if you have these claims, let me know. This provision relates 100% to the access of the plumbing system or other areas of the property necessary to make repairs. Now what the old language said in the policy was, in essence, if you have a loss and you've got some damage, we're going to pay any access necessary to repair or replace that system that caused the damage. And they've now changed it to say that you're only going to get access to that specific point of the system from which the water or steam escaped. It's far more limiting. And what they use this to do is when there's, let's say, a toilet overflow in your property, they say, well, hold on a second, the water that damaged your property was the water from the toilet, so you only get access to the toilet. But if that toilet overflow is the result of a broken drain line, which it often is, you now can't get coverage for that. That's what State Farm argues. But the truth is, that's not accurate. What this says, when you actually dive in and read it, is you get access to that specific point from which water or steam escaped. So if you've got that broken drain line, all you need to argue, and usually get a plumber to do this, is to say, oh, water was escaping from the drain line underneath the property. And that triggers your coverage. That's it. All you need is the water escaping. Our argument is that it does not need to be the water that caused the damage to the property. It doesn't say that. Now, if you want an even stronger case, and the plumber can confirm that yes, not only did the water escape from that line, but that water actually damaged the foundation of the property or the substrate, the backfill that's actually a construction material underneath the property, all of that is enough to trigger coverage as well. So make sure that you recognize that just because they've got this new language does not mean they're not going to owe for that access. The other issue is when they say that specific point, State Farm tries to come in and say, okay, well look, it only escaped from this part, so we're only going to give you this kind of 5x5 square, and that's where you can dig down. But the problem is that line is cast iron, and it's 90 years old, and it cannot be patched. There's no way to sleeve it, because it'll just break down. There's no way to connect the new piping to it, because it's just too old and brittle. The language here is whatever is necessary, building structure necessary to gain access to the specific point. The reality is, it is necessary to do the entire line to gain access to here and make the repair. So now you can get that whole line, if necessary, based off of the plumber. There's a lot of arguments here, a lot of them can be nuanced, but it's important that you recognize that just because this language is in there and State Farm cites it, doesn't mean State Farm is right. You're still going to have arguments to get the access covered for this. All right. There's a lot of details. There's some other notable mentions I wanted to go through. These are going to be much faster, and I'm not going to look at specific policy language for them, but I want to go through them because they're important. And the first one is frozen pipes. The frozen pipe claim is very common in the winter. Right now, no one's probably worrying about them, but when winter comes, we all have them. And what happens is they get put in as a frozen pipe claim. They're identified by the adjuster or the homeowner as, oh, my pipe's froze. The reality is we have zero responsibility under that all-risk language to say it was a frozen pipe. And if you have a frozen pipe, if you've got an all-risk policy and what you think might be a frozen pipe, I would highly recommend not putting it in as a frozen pipe claim unless you are 1,000% sure the heat was maintained at that property or that the property was not vacant or empty at the time. Because what you're going to find is if you just put this in as a normal plumbing leak, yes, you might lose the cost of the plumbing. I recognize you can get the plumbing covered if it is a frozen pipe claim. But the carrier on a just a regular broken plumbing line has then the burden to prove that not only was it no heat was maintained, but the break itself was the result of a frozen pipe. If they can't do that, if the carrier can't prove that the break was the result of a frozen pipe versus just a normal break in a plumbing system, they don't have to worry about whether or not the heat was maintained. So let's use an example. You have a supply line in a wall that bursts. The homeowner has a responsibility to protect the property from further damage. They absolutely have to call a plumber to stop that leak as soon as they find out. Plumber comes out, does the repair, writes their report. Claim gets put in as a broken plumbing line. Carrier comes out and says, okay, plumbing line broke, let me see the invoice, here's the invoice, okay. Covered claim. Or they want to come back and say, well, was there heat on the property? You're going to say, I don't know, but it doesn't matter. There's no requirement for heat under a broken plumbing line. They're going to say, well, was it a frozen pipe? I don't know if it was a frozen pipe. It was a broken plumbing line. They called the plumber out. And now they have the burden to try and figure out whether or not it was a frozen plumbing system. They've got to do that investigation. Now, if it comes back and it was frozen, you are in the exact same position you were in had you reported it as a frozen plumbing line. So why not try getting it in as a broken system and seeing what the homeowner does? Seeing what the insurance company does with it. I highly, highly recommend this. It would save a lot of fights. Stucco and siding claims. This one's really interesting. As part of MAPIA, we did an entire class on this, on how to get these paid. So if you want to know the deeper answers to this, I'd highly suggest joining MAPIA so you can get that type of information. But I will tell you that with stucco and siding claims, if you have an acceptance of interior water damage, you can actually get the stucco or siding paid for as relating to access for those damages if the carrier has already accepted the ensuing loss coverage. It doesn't matter if the stucco was improperly put on by the contractor, which is usually the case. You can still get that paid for. That's some of the great benefits of joining an organization like MAPIA, because you get the details of how to fight such a lucrative claim as stucco and siding. This is a really brief one. Contents are insured generally under most policies up to 10% of the policy anywhere in the world. So if they've got contents in other places, like in a storage container, as a result of a loss and something happens, there is still coverage for those contents. This is my reminder on the burden and the notice on loss type. You don't have a requirement to name the cause of the loss. You just have a burden to say it was direct physical loss of the property. Here's my estimate for the repairs. That burden is on the carrier to then prove the exclusion. Don't do their job for them. Generally, I think this is policy specific, so don't take this for every case and make sure you review your policies, but generally a property under construction is not considered vacant. That's going to come into play a lot with frozen pipe claims, vandalism, theft, other issues where vacancy matters, but generally you should know that under construction is not vacant. Collapse coverage. Collapse is an additional coverage under most policies, and most policies have coverage for it as a result of hidden decay. So this is kind of similar to that traveler situation where they've got a rot issue and then long-term leakage exclusion. If as long as it was hidden in a collapse situation, it doesn't matter if it was the longest leak in the planet. If they didn't know about it and a collapse results, you've generally got coverage. That also applies to just the decay of building material over time. You know, things like mortar and brick walls will break down. That decay, as long as it's unknown to the insured and hidden from view, is going to create coverage for collapse. I'm going to get these up here only because I know another one's coming, another question that needs to be updated. But the next one is vandalism versus theft. And this is going to apply to actually the next two issues. Vandalism is the intentional, we lost the PowerPoint. Now you guys get to see my cute daughter. There we go. Vandalism is an intentional damaging of the property. What's happening? We're losing the slide again. Sorry about that. So we'll keep it up. We'll get the question at the end. I'm okay with that. So vandalism is intentional, and it's intentionally causing damage to a property, right? It's not just rough life, as carriers like to call it. It's intentionally doing damage. Theft is the intentional taking of something, or even unintentional, to be honest. the taking of an item from a property. There is often distinctions within the policy as to when these can apply. It can change with vacancy issues, it can change with tenants, it can change with a lot of things. So you want to make sure that you are using the right language for the right loss. Biggest example is copper piping, right? When a property has copper pipes stolen from it, it generally can fall under both of these categories. It can be vandalism because they are cutting the pipes and purposefully damaging the systems within the house. That's vandalism. It can also be theft because they are stealing those pipes. I've seen multiple situations now where one of them will apply and the other could be excluded. You want to make sure that you are presenting the claim the right way and understanding the difference. And this goes to the tenant issues. I can't tell you the number of claims that I get from insureds where they're a landlord and there's damage to a property after a tenant leaves. And too often, they will come in and say, well, look, I think it was the tenant that did this, we reported it, we put a police report in, and the insurance company denied it because they said it was the tenant during their tenancy, and that's not covered under the policy. Well, the truth is, unless you were there with a video camera watching this happen, you have no idea who actually caused the damage to your property. You don't know if it was the tenant. You don't know if it was one of the tenant's friends who came over and drank too much and had a binge demolition derby in the property to cause this damage. And unless you are 1,000% certain with proof that it was a tenant, never report the claim as damage from a tenant because you just don't know. And now you were trying to do the job of the insurance company because the insurance company has the burden to prove it was the tenant. So unless they have a time machine and can go back, they're going to have a very hard time proving it. So make sure that you put the claim in and argue it the right way when it comes to those tenancy issues. The other issue is as soon as, let's say, an eviction happens for a tenant, the moment that eviction goes through, they are no longer a tenant. Whether they're in the property or not, they are not a tenant. So if they cause damage after the eviction has been gone through and they've been evicted from the property, if they have the keys and go back or cause other damage, it doesn't matter, they're not a tenant any longer and that damage would still be covered. Last but not least is this issue of appraisal versus litigation and the timeline for doing those. And when I say timeline, I don't mean how long they take, I mean when can they be done. Not only was there a number of questions on this, we've actually been fighting this pretty hard over the past 2 years, and we've yet to lose one, actually, now that I think about it. Lawsuits have timelines within almost every policy. There's a suit limitation provision that says 1 year or 2 years or whatever the case may be. Some states are 3, some states up to 6 or 8. So that limitation is contained within the policy, and it applies to filing suit. Appraisal is not filing suit. It's not an adverse situation where you have to get the courts involved. It is not a lawsuit. Completely different. And the most important thing to recognize here is that appraisals don't have timelines within the policy. All the policy provisions generally say is that they have to be differences to value, you demand appraisal. That means if you are past your 1 year suit limitation or your 2 year suit limitation, you can still demand appraisal. I hope you got that because it's incredibly important. If you are beyond the suit limitation and you feel that there is still a disagreement as to the amount of the loss, demand appraisal. We've had a few carriers attempt to say, hold on a second, we're past the suit limitation, we're not going to appraisal. And that's their reason for not going, is by saying, you can't sue us, so we're not going to go. Well, we have sued them in that situation, and the courts have agreed with us that refusing to go to appraisal is a different breach of the policy than the policy provisions regarding coverage, and thus it's not subject to the same suit limitation. So if you get this situation where you're demanding appraisal and it's getting denied simply because you're past the suit limitation, let me know. We've been very successful in fighting those cases. We also have been very successful on this. When appraisals do go through and the carrier doesn't pay the appraisal award, we've actually gotten some bad faith awards on that, even in settlement. The carriers have been paying over and above the award because they recognize how wrong they ultimately are. So we're happy to help with both of those. All right, that was a lot for the actual class itself, and I do want to get through these questions. I've seen Vinny typing a few in, so I appreciate you guys asking questions. If you have anything additional you have questions about, let us know. We've got the chat open. You're good to go now. So we will add those in as we're going through these, but I want to make sure I address these questions. These were all questions that you guys presented before the class when you did that initial form, Continue to do that, guys. It's really helpful in preparing to want to know what you guys want to know. In that same vein, if you guys have a desire for a specific class, let me know. Shoot me an email and say, hey Tony, could you do a class on X, Y, and Z thing? Really want to know more about that? I would be happy to do that. I'm always looking for good ideas. So this first one, what do I do when I need a contractor to repair a roof to protect from further damage, but that repair would destroy the evidence of that damage, i.e. a flat roof? Well, this one comes up a lot, and I've fought cases all across the spectrum on strength when it comes to this issue. In a perfect world, you would have photographs of the damage beforehand, clearly showing what it looks like before, multiple angles, really document the hell out of it, and then have the contractor do the repair. The reality is the policy does not require any type of photographic documentation or even require inspection before repairs are done. The policy only indicates that you have a responsibility to protect your property from further damage and keep accurate receipts. That's it. Nothing about photographs. Now, I have fought those as well, where you've got a flat roof that's got new tar spots where the roof is lifted up. Carrier says, well, we can't find any wind damage. I said, well, of course not, because it's tarred over. You see the spot. By the way, did you talk to the roofer who did the work? Because they generally don't. And I always get them to admit that the best person to say whether or not there was wind damage is the one who did the repair. But I'd rather not have to have that fight. If we can take photographs and have them in the record, you should. Take the photographs, present them to the carrier. You've done everything you need to do. If you really want to be careful, just notify the carrier immediately that the repairs are going to be being done and that they should send someone out immediately, i.e. same day, to take a look. Otherwise, the repairs have to go forward. Is building code compliance covered under RCV or a separate coverage? So this is really interesting. There was a lot of code questions, and I'm tempted to just do a whole class on code issues because there was a number that came through this time. Code coverage is generally an additional coverage under the policy. Ordinance and law is one of the terms for it, but you've generally got it as an additional coverage under the policy. It is still RCV coverage in the sense that you get all the way up to replacement cost coverage on it, but it's almost kind of a non-issue because if there's code upgrades that are necessary, there's no ACV payment because it was never there before. There's nothing to depreciate. A lot of times the code coverage is a incurred cost, so make sure that you're recognizing that that's something that you need to account for as the repairs are being done, not necessarily something you can get as an initial payment. When a structural engineer visits the site but sends the information to another structural engineer who is not licensed in that state, can you combat this? Short version is no. There's no real way to combat it in the sense that you can't force another action. Carriers are free to use whoever they want. They can use unlicensed people. They can use Joe Schmo from down the street. They can use someone from Honolulu for a case in Pennsylvania if they want. Now that weakens their case certainly, but there's nothing you can really do to force any other conduct. There's just no guidelines or instructions for carriers on how to do that. It's the same reason in a number of states the adjusters that work for insurance companies have no licensing. They've got no requirements as to their knowledge or proof that they know anything. They could literally be someone who just graduated high school and has done a few hours in the field. So there's not much we can do, but it's certainly evidence we can use in the event of a lawsuit to say, well, who are you going to trust more? The licensed person from the state who we have, or the unlicensed person they had to send it to with some photographs to do their report? Does code coverage increase policy limits beyond those listed on the deck page because it's an additional coverage? Great question, and actually just had a final review on a similar situation. It was for debris removal, not for code coverage. The short answer is unless the policy provides a specific additional limit over and above the policy limit, it doesn't provide additional coverage. The policy is really one area very clear that all you get are your policy limits unless there is specific language that increases that number. Now that happens a lot with something like debris removal, where you can get an additional 10% on top of the policy limits. But a lot of times the code coverage doesn't have that. And sometimes it might, but you're going to want to review the policy language specifically. Just because it is called additional coverage does not automatically mean it increases the policy limits. I understand the argument, and conceptually I get it, but it's just not the way it works. What are reasons for an insurance company to drop you, and is this legal and ethical? There's a lot of reasons they can drop you. The reality is dropping you changes whether or not you are within the policy period or upon renewal. Upon renewal, it's pretty much fair game to drop you for almost any reason. There's still some restrictions, but upon renewal, what the courts have come down and said is, look, we can't force two people to be in contract with each other. Dropping you mid-policy is a lot harder. You're pretty much going to need to show material misrepresentations or fraud of some sort to be dropped in the middle of a policy. If you've got a situation where an insured is being dropped even upon renewal, I would highly recommend contacting your local insurance department and making a complaint. And all you have to say in the complaint is, look, there's still an open claim. I can't get other insurance as a result, and I'm being dropped. They're leaving me, in essence, uninsurable. That's not fair. A lot of times the insurance department will actually step in and say, yes, you have to renew them for that next policy term because you're still in the middle of a claim. The insured suffers a theft loss. The carrier pays for 8 items but denies coverage for the 2 more expensive items, citing policy language requiring the insured to provide documentation of proof of ownership, which the insured does not possess. Unfortunately, this amounts to only a $1,600 issue, so the carrier feels the insured has no recourse. Is the carrier correct? Side note, the insured was also unable to provide documentation on the 8 items for which the carrier did agree to pay. Where is the difference? Well, the difference is in value. But the truth of the matter is the carrier is going to have a really hard time upholding this. Now, policies have different requirements when it comes to what you have to prove as to what contents you have or don't have in your house. The truth of the matter is, though, most of us don't keep receipts for the rest of our lives for every item in my home. We've got couches in our house, thousands of dollars. Furniture. It's very expensive in people's homes that people don't keep receipts. They could be 10, 20 years old. That goes the same for things like musical instruments, right? Someone a guitar could be a couple $1,000s pretty easily, but you might not have the receipts for those. Maybe you can get lucky and find something like a photograph or otherwise, but even those might not exist. And the truth of the matter is the carrier cannot simply come by and say, look, we don't believe that you have these items because you can't prove anything for them. If the policy language has something like documentation of proof, most of the time it'll be followed with something like reasonable, or it'll have reasonableness before it, or some other requirement that allows for some wiggle room for you. The argument will likely be very policy unique, but I can tell you from experience, carriers are not successful most of the time in upholding these denials. When it comes to the amount in dispute, the $1,600, I recognize that almost no attorney on the planet is going to take a case for $1,600. And one of my thoughts on a class, I'm just trying to figure out the right way to do it, is at least to show some guidance on what it takes to be successful in a small claims court case. Most of the time, if there's $1,600 in dispute, I tell the homeowner, file it in small claims court. You can represent yourself, you don't need an attorney, they make it very simple for you. And that is what I would highly recommend them doing in that scenario. The other option is always involving the insurance department. Now, the insurance department doesn't really like to get involved in something that's been denied, or the nitty-gritty of policy language, but it's certainly worth a try. Those are most likely your best choices, and if you've got any questions about that small claims process, again, I'm happy to help. Most carriers don't issue specific coverage denials. In most cases, they will create a bunch of policy language, they will cite a bunch of policy language exclusions, but do not provide a clear connection between the exclusion and the items they are denying. What standards do the courts hold the carriers to when it comes to articulating their denials? Great question. So the carriers have to do 2 things in most states. They have to cite facts and they have to cite policy language. Now, generally the rule of thumb is those are going to have to kind of make it clear as to which ones apply. But that doesn't always happen, right? We have a case right now that's going to trial where the insurance company is cited 17 different provisions, which our adjuster wrote back and said, well, look, we don't know which one of these you're actually applying because you're just citing an entire section of a policy. Can you give us some clarification? And the carrier refused to do so. We found some great case law that says the carrier in that situation cannot withhold the knowledge as to what provisions they are actually applying here, because it's obviously unfair, right? How do we fight back if we don't even know what you're fighting on? So if the carrier doesn't both cite facts and cite language that tie the 2 together from the policy, there's a good chance they're going to be in breach of some either unfair trade practices law or some other regulation under the insurance acts of each state. If you've got a specific state question, I'll be happy to review it with you and go through whether or not it is an actual breach. But the short answer is you're looking for both facts and policy language. How do you combat when they won't pay for continuous carpet flooring that runs under a door slab but does not have a threshold? It's a great question, and usually the best way to combat it is through their own payments within a policy. So what I use all the time is something like trim on a floor or painting of walls in a room. They've accepted to paint all of those walls or all of that trim because they recognize they owe for the continuous nature of items under the policy. It's got to be uniform appearance. Once they do that, once you've got that evidence that they've done that, all you have to do is show, look, there's no physical difference between that. If this door is open, it's just continuous straight through. The same reason you, by the way, didn't patch just that one corner that got wet in the room, you redid the whole carpet. The exact same thing matters going out into the hallway. The fact that there is a door there without a door doesn't matter because that door stays open. It's no different than if that door wasn't there. Take the door off the hinges for all I care. The fact is there's no actual difference from an open walkway. Use their own payments against them. You can also, if you keep a nice bank of claims, you can use prior payments from that same carrier against them. So let's say you've got Allstate, one adjuster paid it, the next one doesn't want to. You can use that prior payment and say, look, Allstate agrees that this is covered. Here's a prior payment on this exact issue. You can't change your position now. That works really well against them. How to identify the difference between a misrepresentation and a material misrepresentation of policy provisions? Short answer is you don't. You call an attorney. This is getting really in depth into what qualifies as law and what will be state specific. If you've got an issue of whether or not there's been either a misrepresentation by the insured or by the carrier, you're going to want to talk to an attorney at that point because those issues become so law specific that you really shouldn't be making that call without speaking to an attorney. When clients do not have ordinance and law coverage and the client has no existing ice and water barrier on the roof and it is required currently by city code, how does one advocate for ice and water being part of the proper installation and is not a code upgrade? I have provided proper roof installation specifications of roof manufacturers with pictures, but Allstate claims that since the client does not have O&L, they will not pay for what is not there pre-loss. Lengthy, but good question. The fact of the matter is this is why O&L coverage exists, for situations where it's not there but is necessary to put it back. There is a difference between code upgrade coverage and getting back to a repairable condition. What do I mean by that? There are situations where the sheathing on a roof isn't the right thickness, or something else is necessary to get to a nailable surface to repair a property properly. Even though that might be a code issue also, it is necessary to necessitate even the repair to get it back to the way it was before. Right? Think of, or another good example is something like asbestos, right? You can't put asbestos tiles back up. Carrier's not paying you for asbestos, not because of the law, but because it's simply not possible to be doing it. This, however, is something that wasn't at the property at all. And ice and water shields, I recognize that they are necessary, that any roofer is going to charge for them, but the fact of the matter is, there's no argument that I've ever seen be successful that allows for the carriers to pay for this if there's not that code upgrade coverage. Because all they're going to say is, look, it wasn't something that was at the property previously. It's not a situation where it was damaged and needs to be replaced because of a code upgrade. It's something that wasn't even in existence. We can't possibly have to pay for that. I wish it was, and I certainly understand the argument, but it's just not how it works in the field. Within what time frame can a denial be reopened if it smells of bad faith and it is in violation of the principles of estoppel? Forever. You might be surprised by that answer, but it's the truth. There's absolutely nothing in the policy that requires any limitation on how long a claim can stay open or when a claim can be reopened. It can go on for as long as it needs to get to the right result. So make sure that you guys know that when you're opening these things. And again, one of the great things and kind of the great end arounds to all this is if you're let's say you're past that suit limitation, you reopen a claim, you can make that demand for appraisal. And if that demand for appraisal is refused, now we have another avenue to litigation that might be worth pursuing. Could they interpret or any part as the repair? So this, I think, is relating back to the Allstate question, where the Allstate policy states they can either repair, replace, or whatever it is, or pay for that item or any part of that item for the repair. And the reality is no, because what they're talking about here is that specific part of the wood floor. Maybe they're going to say, and this could be an argument that I'd like to flesh out with some thought. Well, they're paying for the specific boards that were damaged, but not paying for the rest of the floor. And they could say, well, maybe I'm just going to pay for that part of the floor and replace those. But they're still going to be in a situation where they're not bringing it back to pre-loss condition if they're doing that, and they're not allowed to pay to sand and refinish just for matching purposes. So you still have a great argument for repair. A great argument for replacement of that floor. It can get very nuanced, and I'm happy to talk it out, but this, I've seen it personally be successful on Allstate claims, so they don't come back and ultimately say, well, I'm only paying that small piece, because it's just not how the claims are ultimately paid by them. Isn't the hardwood floor finish part of the damaged property? What if Allstate just pays to refinish and claim they fulfilled their obligation? Yes, the finish is part of the damaged property, but most of the time with these water damaged cases, you've got some version of cupping to the floor, some gaps that are created as a result of shrinkage or expansion in between the lines, different bevels as a result. One of the great arguments I use all the time is if it's a beveled wood floor and you sand it, you're now changing the appearance of the floor and the beveling. Not to mention, you're also changing the longevity of that floor. You've now taken away a sanding that they could have had the option to do later, and not done it not done it as a part of this loss. So you could make an argument that, look, you can't sand and refinish this floor anyway because you are taking away an option that they had in the future, that option to refinish the floor if they wanted. So yes, they can absolutely make an argument that the part of the damaged property was the finish, but if that water gets all the way through to the hardwood itself, you're not getting that stain out, so you're going to have to do the work anyway. All right, I think we were done those, and we couldn't get rid of them. So, let's go to that last slide. I don't know if I lost it. See if we can pull it up. But I think those are all the questions. Oh, there might be one more. Let me see. What's the last question? Sorry, we lost some control over the PowerPoint. If we sell our home and put items in storage while we live abroad, how to ensure that personal property is covered in another country? All right, that's a good question. So if you've got a loss where you're going abroad, first, your items are still going to be covered under that under whatever homeowner's policy you get for up to 10%, under most policies. So that's issue number one. If you want, you can always actually get a separate coverage for just your personal property contents that are put in storage. You can either do it through the storage companies that I see often, or you could do it through any homeowner's policy and only ask for contents coverage for a specific purpose. So you've got both of those options. But even if you go abroad, you've still got up to 10% of that coverage under most policies covering that stuff. Again, you're going to want to look at your specific provision, but otherwise you should be okay. Now normally there's a last slide that says thank you. I do want to thank everybody today. I know we went a little bit longer than my goal of an hour, but I really appreciate it. These are all provisions that we constantly have to fight over and over again. So hopefully you guys got something from this. As always, if you have any questions whatsoever, give me a call. My phone number again is 609-354-8009. I am happy to take any phone calls or questions from you guys at any time. You can also send me an email. Go right to my website. You can get this information there as well, wdblegal.com. Happy to do it that way. Guys, this will be available if you need to come back for any reason right on Facebook. We're also going to be getting them on the website. Please let me know if you have any other questions, suggestions for future classes. I'm happy to do it. Thanks so much, guys. Have a good one.